One. Welcome everyone to our new veteran education series. Today we are having a guest speaker, Kristen, who is going to be presenting about Estate Planning 101, sharing some vital information for us today. I'm your host, Chris Jackson, and with me is Josh Thompson. As we've discussed before, I work with business owners and individuals with protecting their lifestyle, loved ones, and assets. And Josh, he helps with the tax solutions, and he is a great tax professional that really likes to strategize with business owners and veterans. Today we have with us Kristen. A little bit more about Kristen. So Kristen has been in the law for quite some time. Originally, she's from New York City. She's an entrepreneur, corporate, and nonprofit legal specialist and business coach with over 25 years experience in the corporate world. She has a myriad of accolades for her own companies as well as her legal practice. So with no further ado, we'll welcome Kristen to just jump right into it and share some information with us. So Kristen, the first question for you is, what happens to your assets if you do not have any prior estate planning?
Well, thank you guys for having me today. And I just want to preference my responses with the fact that I'm speaking under Utah state law. And when we do estate planning, there are state and federal tax implications. And so please understand that this is a high level discussion and that if you have any more specific questions, we can address those offline. So what happens to your assets if you do not have prior estate planning? A lot of times people say, oh, I'm fine. I don't need to have an estate plan. I'm not going to die anytime soon. When you die without thinking ahead about what happens to your estate, you leave your family and friends with, well, mostly your family, with the expense of taking care of your final wishes. And that includes everything from your burial or your cremation to what happens to the distribution of your assets. The average funeral, whether you're buried or whether you're cremated, costs approximately $10,000 to $15,000 depending on the state that you live in. So without a proper life insurance plan ahead of time, you could be in some serious expense that you're leaving your family with. Additionally, if your family doesn't know whether you want to be cremated or buried, that's a dispute that loved ones will get into after your passing. Additionally, by state law, at least here in Utah, depending on whether you're married, certain assets will transfer automatically to your spouse if you've listed those assets with your spouse as beneficiary or by operation of law. And everything else is kind of a free-for-all. And so you'd have to jump to the statute in order to figure out who gets what. And then there's a lengthy process that occurs that can cost thousands of dollars, particularly if your beneficiaries do not agree on who should get what. For example, I have a real life case right now where I have a dad who passed away, wife predeceased dad, so we just have dad left, and we have two step siblings. We have a son and we have a daughter. Both are adults, both are married. Both didn't even know about each other. And so when dad's announcement went out, daughter came into town and said, I have just as much of a right, and under the statute she does. And so all of a sudden, son, who has been a doting son for the whole life of dad, ended up having to split assets with sister that he didn't know about.
Wow.
Yeah, that's crazy. Do you have any feedback or other questions, follow-up questions, Josh?
Yeah, I mean, there's the common notion out there. I've spoken with people. It's like, oh, I don't have that much money. I don't need to do an estate or anything like that. I guess really, what would you say to someone that says something like that?
So it's a common misperception. A lot of people will say, I don't want to spend that money. To probate your estate at a minimum costs $2,500, and that's an estate like Utah where everything is pretty reasonably priced. I recently had the passing of my own father, who despite my recommendation did a will instead of a trust, which we'll get into later. In the state of Connecticut, we had to probate that will. They're taking 10% of my father's estate, right? So if you have a $500,000 estate, the attorney's going to take 10% of that simply to probate the will, right? Even though my sister and I are named as co-executors, we have to go through a probate process because the will did not specifically state informal probate. I had nothing to do with the drafting of that because of undue influence or duress or anything. But if you don't, I have other clients right now. I'm representing a woman who has 8 siblings, just for the court to assign who's going to be in charge, whether that's 1, 5, or all 8 of the siblings, has cost my personal client already $15,000 in 2 years of her life, right? And we ended up assigning nobody. Nobody could agree on anything, and so now the bank is acting as executor of the estate, right? Which is going to cost even more money, leaving the beneficiaries with practically zero. So for $2,500, right, which is the average cost of a good estate plan, in other states probably 4,000 or 5,000, depending on if you live in an urban or rural area, you save yourself thousands and thousands of dollars.
Yeah, and I think that's just that mindset. Really, a lot of us need to get over when it comes down to it. And then I know a lot of people are probably thinking right now, the home that your parents are living in, or you live in, is that part of your estate?
It is part of your estate. When you hold your home, and let's say you're married, so a gentleman is married to his wife, and he holds that in joint tenancy right of survivorship. If he were to die, then automatically the home would title to the spouse. If he does not hold that in joint tenancy right of survivorship, in just joint tenancy, then you have to probate the home through the court, costing thousands of dollars. If mom is not doing well, or if the children, let's say parent did some estate planning and left the home, that's another thing. And Josh, you could probably speak to that. So let's say that you want to change the title to the house to the children before you die, right? Now, mom and dad bought the house 20 years ago, and they have the benefit of the tax basis, right? If you transfer that house in the lifetime to the children without the proper estate planning through a trust, now the children have a taxable implication and don't get the benefit of that, and end up paying the differential on the increase in the value of the house. So it's important to work with your trust and estate person as well as your tax advisor, who oftentimes could be in the same office or working together as affiliates.
Yeah, I definitely agree with that. I have one client that literally just did that as well. Before they started working with us, they ended up giving their home to their children, and not realizing, oh man, that step up in basis completely, lose it when you do something like that. And now that we're talking, it's like, oh, man. But if only. That's why you work with a professional earlier than later. But all right, Chris, I'll kind of give back to you, man, if you want to move on to the next question.
Yeah, for sure. So we kind of already discussed this. What's the main difference between a will and a trust? And so in essence, just to kind of talk to the audience with what you just said. Basically, the will is a temporary just declaration of where a trust is more defined. Correct.
Well, the will is not so much temporary as much as it's still probatable, right? So when you draft a will, and it's usually much cheaper, it's $400 to $800 depending on the market that you're in. Sometimes $1,000. You really shouldn't pay that for a will. You really should. If your asset base in every state's a little bit different, right? If your asset base is sufficient enough, if you own a home and you have some investments, you should be sufficient enough to be able to do a trust, right? And a trust keeps you out of the court. A will does not. Even if you put informal probate, if you have a dispute under your will, you're still going to be subject to thousands of dollars of court fees and processes and right to claim statute periods. And there's a lot, I know I'm talking about a lot of different things, but it boils down to time and expense. So to save $2,000, you're going to spend 10 in court just to probate a will if anything goes wrong. At the minimum, so like I said, my own father has a will, and I'm paying this attorney a lot of money to probate a will where he already had his wishes set forth. Alternatively, with a trust, you're out of court. The trust names who the trustees are, and there's lots of flexibility in a trust so that if you have minor children or a special needs adult child, or you want to leave certain assets one way, certain assets a different way, you can create little pots of income for kids that get it at different times. You could disown somebody entirely. If you do that, I highly recommend putting a small paragraph as to why. You can do something called the dead hand provision, where if you have a child that has a drug addiction or a spouse that has a drug addiction and you don't want the money going to your spouse and then never making it to your kids, you can bypass that whole thing or require a drug test. So there's lots of flexibility in a trust. It keeps you out of court, and it also usually comes with a comprehensive package where you do have a will alongside of your trust. And what that will is affectionately called a pour over will, at least for me. And what it says is, hey, I can't think of anything and everything, and I'm going to live my life. And in a revocable trust, you control your assets. It doesn't feel any differently. And then you have this will that says, in case I forgot anything, it pours over into the trust. However, you do have to put any assets that are larger and require beneficiaries. You have to name the trust as the beneficiary. Bank accounts, titles to homes, investment accounts, life insurance policies, and so forth.
Ah, got it.
Great to know.
Yeah.
You have any follow-ups, Josh?
I mean, yeah, I think you hit everything on that one that I had. Unless you had anything you want to add, Chris.
No, that's great. Yeah, thanks for the clarification. So the next one that we're going to talk about, you discussed it a little bit about the revocable trust. So can you explain a little bit more detail what the difference between a revocable and an irrevocable trust is?
Sure. When you have a revocable trust, you're able to live your life like you normally do. When you have an irrevocable trust, you cannot. Once the trust is set, it's set. So a lot of people will misunderstand that, and there's a lot of charlatans out there, and they'll say, oh, why don't you put your car in an irrevocable trust? That's ridiculous, right? The car is not going to survive your lifetime. It depreciates. It's not the type of thing that you would put into an irrevocable trust. The things that go into irrevocable trust are assets that you know that from the period of creation until your death, generally speaking, I mean, there's always caveats. These are the things you're not going to trust, that you're not going to change. In contrast, in a revocable trust, you're going to have the ability to change that because you and or your spouse are the trustees, the co-trustees of your trust. And so that as your life is happening and you're acquiring or situations change in your life, this trust gives you the flexibility to move assets around so that you can tax plan better, you can have investment tools serve you better, and you're able to plan better. Then if you do hold it in trust with a spouse or a partner of any kind, right, and you predecease that person, your side of the trust locks down. So you can be sure that everything that you want locks down. So that's really the main contrast. If you want flexibility to change things, it's revocable. Once you put something into an irrevocable trust, it's untouchable.
Yeah, I do have one comment about that. I had a client that I met with who they own quite a bit of assets, and they had an irrevocable trust for a special needs child. However, the problem with that is it was not a special needs trust. And so the attorney actually had to unwind the irrevocable trust, which was very expensive, just to turn it into special needs trust specifically for the assets delegated to the kid. So I would say, being in the life insurance space, if you have, say, a paid-up whole life policy, that is a great place to put it because that is going to be there no matter what. But you just want to make sure that that specific sum of money is going exactly where you want it to. Do you have anything to add to that, or have you ever had any experiences with irrevocable trust having to be unwinded, or someone thinking something is more permanent, like a business? Like, does a business typically go in an irrevocable trust, or would it go in a revocable trust because it's often sold and sent to someone else?
Are you asking me that question or Josh?
Yes.
Okay, so I usually, people think differently about that. I usually put business interests in a revocable trust because a lot of times the clients that I work with are looking for growth opportunities, joint venture opportunities, exit opportunities, right? That being said, the business itself, I'm not putting in the trust. You can put ownership interests. So if you're an executive and you have ownership interest in many different companies and you're getting residual income, you can put something like that in if you know that that's where it's going to be for the next, decade towards your sunset of your life or something like that. I mean, people do it because they think that creditors can't get through that. And that is indeed correct. But like you mentioned before, if something changes in your life or you needed to modify that, the expense to unwind an irrevocable trust is extraordinary and time consuming, frankly.
Do you have any insights on that, Josh? Any experiences with people with those type of trusts?
Not too much, really. There's one individual that comes to mind, but it was more on the going the will or the trust side of things. Yeah, I think what ended up happening, he didn't have too much family. He had a trust, I want to say, but he didn't have a trustee appointed, and he ended up the family couldn't agree, kind of like what you were saying, on who does they want to decide to be the trustee. They ended up finding someone to do the trustee that usually does trustee work, and obviously it's not free going through someone that's going to do the trustee work, and it was just more of the assets taken care of. So, I mean, that's really the biggest experience that I had when it came down to wills and trusts that may have not have gone the best route.
Awesome. Well, let's go on to the next question. The last question to kind of summarize and go more to the direct veteran audience is there any specific ways that estate planning can be beneficial for veterans and their benefits?
Absolutely. So I want to talk about pensions here and about the distribution of your pension benefits and whether or not you can add on. There's always an additional piece that you can add on depending on the care that you need in your life as you lose capabilities, right? So some people need to go into assisted living per se, and there's lots of formulas that go on around that. And so your pension pays out a certain amount of money, but you're eligible for a bump in aid and assistance depending on whether or not you can do life tasks, right? So if you can't do 2 or more life tasks, for example, cook yourself a meal, your mobility is limited, dress yourself, bathe yourself, things like that. You qualify, for example, for an additional piece of aid that comes with your pension and your benefits. However, you have to balance that against the rent, the portion of your assisted living occupancy, right? And you balance that, right? They do formulas to determine whether or not your current assets allow you to have that additional bump, right? And so let's say that you're doing the math and you realize I'm going to need some full-time care sometime soon. Maybe not full-time, but assisted living type care. And so where a trust or an estate plan can help with that is you can create a trust specifically for your medical needs. You can create a trust for putting some of your cash related assets into that so that you do qualify from an income perspective in order to get that additional bump in your pension. If you create that instrument during the time that you need the additional aid, how the law works today, and this is one of those caveats because the law is subject to change all of the time and limits change, and you can check a specific website to determine what these amounts are. But I think it's 2021, if you create that, right, depending on how the math works, it's 2.5 years from the date of creation of that trust until you can actually claim that additional benefit. If you plan ahead, because you know how much things are likely to cost or will cost, you can sequester that portion of your annual income. And I have a whole presentation on this exact topic with examples and math and everything else. But generally speaking, you can sequester the portion of your income that would preclude you from getting your additional benefits while keeping your current pension, getting the additional bump, and not having to go through this wait period in order to get maximum benefit payout, right, for your assisted living.
Wow, that's great. I did not know that. That's it's actually very similar to a special needs trust in what you're trying to do and allocate funds that are being distributed to the kids who will otherwise be disqualified if they have more money that is in their name. Is that kind of similar in that respect, where you're basically taking it out of your name, so it's money that's earmarked outside of your personal income?
That's right. Special needs trusts are an animal all on their own, but in this case, it's basically saying you can't touch this pot of money because when you create a trust, it's a legal person, right? Just like you and me, it's its own thing. So you can't take money from Peter and give it to Paul, right? And then use it for that. So you're saying, no, this is Peter's money. You can't touch it. Paul's the one who needs the care, right? And so, but I do want to have an important note is that assisted living is not always in a facility. So if you qualify in that you can't do 2 life events anymore by yourself, dress yourself, bathe yourself, make yourself a meal, etc., you can have full-time assisted care in your home. And so what's great about that is a lot of times people don't want to go into a place. And so if you figure out a way to maximize your pension and that additional aid and assistance, which so my father was in the Army right before, he passed away recently. We did qualify for an additional $1,900 on top of his already benefits that he was getting, which would allow him to live in an assisted living facility, which he never made it to. But during the time prior to getting into the hospital, we had full-time nursing. We had all kinds of nutrition management, pain management, and things like that going right to the house, and benefits paid for all of that because we had planned ahead.
Wow, that's amazing. I think that deserves a whole episode, and love to kind of dive a little bit more deeper into that, because that's some like great benefits that people out there just don't know about. That veterans, when they get to a certain age and a certain time in their life, they're like, oh, this is how it works now. It's like, no, speak with a professional, because things could be completely different. Just to get what's out there that you can actually utilize and observe as a veteran or even an elderly individual. Go find out what's out there for you.
Yeah. And it's not easily navigable without the help of a professional, because it's really there's a lot of math involved. There's a lot of changing pieces. And so it's really important that not only when you create your estate plan, preferably a trust plan, that you go back to your professional, regularly. I would say every 2 to 3 years, and or during any life event. You got married, you had a child, there was, some things happening in your life that you consider to be material important. You go see your professional again and make sure that everything is still up to date and works to your maximum benefit.
Fantastic. Yeah, I appreciate your time, Kristen. I think we could be here all day talking about estate planning. So we should wrap it up, and that could be for another series. So any final thoughts for us to leave us with before we head out? You kind of were summarizing on your own. Is there any last thoughts or words of advice?
Just that you take the time to maybe contact your tax professional, your financial advisor, find a reputable attorney. There's plenty of listservs that you can look up online. Even Facebook message you guys, the co-hosts, and figure out a good set of resources. The time and money that you spend now will save you thousands and thousands of dollars in heartache later.
Yeah, I definitely agree with that. Well, Kristen, before we head out, any last minute thing on, as in, how can the people find out about you, or how can they look into you a little bit more, reach out to you?
Well, my contact information was on the beginning slides. My law firm is Raffoni Designier Legal Services, and my contact number is area code 385-414-2114, and I am part of the Facebook group that y'all are in.
Perfect. All right, looking forward to it. Well, Kristen, thanks again for being with us today, giving us all this knowledge, information. I have a feeling you'll definitely be back and we'll be talking again. So other than that, thank you.
Thanks, you guys.